One of the top reasons that employees sue employers for violation of their civil rights has to do with a qualifying factor called national origin. And in today's video, we're going to talk about national origin, and I'm going to talk to you about a particular case where an employee had a very thick Korean accent, and she brought suit against her employer alleging national origin discrimination. I'm going to tell you what the employer did, how they defended the suit, and what the takeaway is for you as either an employer or an employee. Hi, my name is Peter Lamont. I'm a business attorney and the host of UTL Radio. And inside today's video, we are going to discuss national origin discrimination. So first of all, let's just briefly get a handle on what national origin discrimination is. It is one of the trigger points, one of the factors when considering whether or not you are a victim of discrimination. And in other videos, we lay out the entire list of basis for discrimination lawsuits or civil rights lawsuits. But today we're going to focus only on national origin. So I want to read the exact definition from the U.S. EEOC, the Equal Employment Opportunity Commission. So it's a very good definition. So basically, it's unlawful to discriminate against any employee or applicant because of the individual's national origin. No one can be denied equal employment opportunity because of birthplace, ancestry, culture, linguistic characteristics common to a specific ethnic group, or accent. Now this is important because I told you at the beginning of this video we're going to talk about a case where an individual brought suit against an employer based upon her accent. So let's get into that case. So this is a case, it's a Third Circuit Court of Appeals case, and the name of the case is Park versus the Secretary, United States Department of Veterans Affairs. So let's cut through the facts. Let's just get down to the causes of action. She claims in her lawsuit that her direct supervisor couldn't understand her accent and often made comments and criticized her for the way that she said certain words and the fact that it was very difficult to differentiate between words when she would say certain things. So, you know, when she'd say one word, it would sound like another, and the other would sound like that one. So, very difficult. And other people in the employ of the defendant agreed with the employer that she had a very, very thick accent. And what would happen throughout the course of her employment is that the employer would say things to her like, "I don't understand you. Can you clarify that? I don't understand what you're saying." And now she alleges some other things that seem to be a little more, maybe spiteful, not really hateful. It doesn't really rise, even in her allegations, to a level of alarm. But it's things that make her feel uncomfortable. And she felt that she was reprimanded because of her accent. Now, she sues, and ultimately the Court of Appeals finds in favor of the defendant, the Department of Veterans Affairs. And what the Third Circuit says is that it is not per se, not automatically discriminatory to comment about somebody's accent. It does not automatically trigger a cause of action for national origin discrimination. So, this case is different from the standard cases where an employer might be, absolutely making fun of an employee's accent or not giving them a promotion solely because of the accent, even though they're qualified to do the job. This case is different. This case involves an individual who has a very thick accent. When she spoke to the court, it was clear. Everybody knew she had a very thick accent. And her employer made comments that were not meant to be discriminatory. They were solely meant to tell this woman, "We don't understand you. You must clarify what you're saying. Please speak slower." And the Third Circuit said, as long as your intentions are not discriminatory, you're not trying to single out this person and make fun of her or in any way criticize her. You're simply stating a fact. That is not national origin discrimination. So even though Title VII of the Civil Rights Act has or lists accent as one of the things that you cannot use as a factor in either giving someone a job, deciding to give them a promotion, firing them because it's protected, that doesn't mean that simply by telling an employee to speak slower or we don't understand what you're saying, that's national origin discrimination. So, that's what this case says. What you should take away from this is, obviously, one of the key factors that you need to work on if you are an employer is training. Training of your staff and your supervisors. Let them know what they can and can't say with respect to people with accents. It's a very dangerous thing when you don't train your employees, because you might have an employee who gets frustrated with somebody with an accent and then says something that is, retaliatory or discriminatory. And then you, as the employer, have a problem. So if you've got questions about this topic or this video, I encourage you to give me a call at 973-949-3770, or you can email me at plamont@peterlamontesq.com. I'd be happy to talk to you about national origin discrimination or civil rights lawsuits sounding in discrimination. So feel free to give me a call if you have any questions. Please also post in the comment section below. Let me know that this is something that you guys are interested in. It helps me when I get comments and feedback from you guys out there. It helps me create better content, stuff that you are really interested in. So please post your comments, give me a thumbs up. I will see you next time, and thanks for watching.